are on your motorcycle, you are in your pen. I mean, pen is motorcycle, the same thing. If you are in your keke, I want to say thank you very much for listening to this special production. This is a production that is specifically focused on the investigative reports on the allegations of jury tampering slash misconduct growing out of the case the Republic of Liberia by and through Justice, a Minister of Justice. So, in other words, the Minister of Justice is prosecuting someone here by the Republic of Liberia by and through the Ministry of Justice versus Samuel Twe et al. So they only mention Samuel Twe, but et al. Means that the rest of the people are embedded in that defendant group. And this case took place at the Criminal SRCC, in other words, Criminal Code C for Montserrado County, Republic of Liberia. And this report was out by July 21st, 2026. I want you to know that it's just a few days ago. Today is the 26th. And again, thank you for listening to this special and tuning into this special program. For those of you who are on the social media, those of you who are watching us via the Blaze Online TV, I want to say welcome to you. And if you do not know, you can also listen to the radio station live from any part of the world. Once you have an internet and you have a cell phone, you will be able to listen to or to watch this production and all production, and you will listen to all production of the radio station. Remember, Blaze Radio 90.7 FM is a 24-hour radio station. At least we are 24 hours here. Maybe in the future we will not, but for now we are 24 hours, and we want you to get everything about the radio station. And so go to Blaze Online TV. Go to your Facebook page, type in Blaze, that's one word, online, that's one word, TV, another word. And scroll down, you'll see the poster, the Blaze Radio, online radio poster. Go ahead and tap on it. It's going to take you to the Blaze Radio page, and you tap the play button, and you will be listening to me right there and then. Again, for those of you who are interested in the judicial process, you can go ahead. You can turn it to your side until you finish, then you turn it back. So, those of you who are interested in the judicial process, and those of you who really want to follow the program, follow the judicial process, the Samuel Twe and all case, you have been wanting to see to read for yourself. What did the report say? Samuel Twe may say one thing, the government lawyers may say another thing, and those who are other lawyers who have interest, fanatics, partisans of other political parties, the Unity Party and Congress of Democratic Change, they have their own objective. Maybe they have read it, and then they tell you something that you don't know. And you want to make sure that you hear what the report say, word for word. This is a special feature for those of you who are interested in the legal process. And by doing this, after this, we'll take few calls just for you, for your reaction, for your interaction. We will take few calls. We hope we should be done here by 2 o'clock. We put 2 hours aside for this. And so I'm going to be reading this report word for word. And then if there's any question I need to ask at a certain point, I will ask the question. If you have pen and paper, jot it down. If you have pen and paper, just jot your question down or jot your point down or write your point down. Instead of saying jot, just write your point down. And later on, you can ask a question, specific question based on the pages. So I'm on page 2 right now. I just read page 1, which was the title of the case. Again, just to recap, and I don't want to bore you down, just for you to know, the title of the case of this report is the investigative report on allegations of jury tampering / misconduct growing out of the case Republic of Liberia by and through Ministry of Justice versus Samuel Twe et al. Criminal Assessee C for Moserado County, Republic of Liberia. July 21st, 2026. My guys are really working hard and I'm happy. You know, and they are putting everything together, producing me very, very well. Clifton, Rennie, and my man Eric, they are here helping me. Okay, so introduction, page 2, introduction. So what I want you to do is, if you are taking your notes, put page 2. So I will try to remember to call the page name, and if you have a specific question, you say there was something you read on page 2 I didn't understand. I can easily go back so that we don't get lost in the middle of our thinking. Introduction. This investigation arises from sworn affidavits filed by three individuals who serve as jurors on the 15-member jury panel. Now, so first of all, I want you to know the difference between the two kinds of jurors. There is one type of panel called the grand jury, and there is another panel called the petty jury. The grand jury are the one when the government of Liberia want to charge you with a crime. They are 12, and the government of Liberia go to them and give evidence or present evidence, probable evidence, not all the evidence. So somebody will say, but the evidence is not sufficient. Well, the jury only need to know that there's something the government has on you that they want to prosecute you for. And so the government present the evidence, and they will come up with an indictment. When you hear the word indictment, it doesn't come from the Ministry of Justice. It doesn't come from the judge. It is a grand jury that prepared the indictment presented by the Ministry of Justice to them to approve. So once they approve that indictment, the charges are approved, and then the government of Liberia has charged you. That's not what we are talking about here. They have nothing to do with this particular jury. This other jury is called petty jury. Petty jurors are people, the government of Liberia, the civil servant, the court will send a message to the Civil Service Administration. In the U.S., they will write you individually, the court will write you individually and say, hey, look, you are a citizen, come and sit on the jury pool. But in Liberia, what they do is they ask institutions, ministries, or corporations, and they say, look, we need this person. Maybe they say Gibson is working with Ministry of Public Works and say, Mr. Minister, we need Gibson Jerry to serve on the jury. And that is what they are doing. Before then, it didn't used to happen. Before then, group of people go to the court, they sit there, they select them, but now they change. And I think it's good. I can say that for our facts. It's good that they are now selecting randomly from the various ministries and corporations and government power sectors. So they come in. Normally it's supposed to be 15 jurors, petty jurors. So these 15 jurors, 3 of them are alternate. Why do they have them alternately? Because when one of the 12 jurors that are supposed to make a decision, when one of the 12 jurors is sick and cannot come, and the judge has to replace that person, the 3 jurors who are alternate, they will take one of them to replace the one that will not come to make it 12. If another one cannot come, they replace it again. If the third one cannot come, they replace it again. Now, nobody's supposed to not come anymore. If one more say they're not coming, that case is going to be stopped. The judge cannot continue. Or that case go to retrial for another sitting. So that's what I'm talking about. Those are the petty jurors. Petty jurors are the ones who make a decision. In the jurisprudence, in Liberian jurisprudence, 9, the majority, 9, 10 can make a decision and you are free. In Samuel 12 case, those who said Samuel 12 were not guilty. There were 9. I think 10 or 9. Yeah, 9. There were 9 jurors. And those who said Samuel 12 were guilty were 3. Now, those are the 3 people that said Samuel that voted to convict Samuel 12. Those are the 3 jurors that brought the complaint. Now you know now what the 3 individuals they are talking about is. So let's go back to the reading. This investigation arises from sworn affidavit filed by 3 individuals who serve as jurors on the 15-member jury panel. The panel was constituted to hear the facts, evaluate the evidence presented at trial, assess the credibility of what evidence, deliberate, and return a verdict of guilty or not guilty. The trial, from which the allegations of jury tampering and misconduct arose, commenced before this court with the selection and subsequent sequestration of 15 individuals to serve as a trial juror. Now, the petty jurors are also called trial jurors. So I just want to let you know that. Because when they use certain words, don't get confused. There are only 2 types of juror in the entire jurisprudence: grand jury and petty jury, or trial juror. So there's something they use a word, it says sequestration. Now, if you don't know the words, you get confused. Sequestration means they tell the jurors, you're not going home today. You will be here until the case is over. You will stay by yourself. You will not listen to radio station. You will not read newspaper. You will not talk to anybody. You will not bring any cell phone. You will not bring any radio for you to listen to. You will not read from the internet. You will stay here and only concentrate on the case. That's what sequestration means. So the report said those people were subsequently sequestrated for 15 individuals, as I told you before, they usually 15, to serve as trial jurors. After a rigorous selection process conducted by counsel for the prosecution and defense, the 4-jury panel was constituted, sworn, and seated to hear the case. I continue the reading on page 2 still. After 56 days of trial. Now you know the Samuel 12 trial took 56 days. After 56 days of trial, the court heard final arguments on May 8, 2026. The jury was then properly charged by the court in accordance with law and retired to the jury room to deliberate, evaluate in the evidence adduced at trial and return a verdict. What does it mean? What does it mean when they say the court charged them? So somebody will say, but when they charge them ever since before they go, even disciple case? No. When they say the court charged them, mean the court tell them what the law is, what they need to look at. When you go in your room, you're not going there to go and judge people by your feelings. You're not going to judge people because you don't like them. You're not going to judge them because they hurt your boyfriend or they hurt your husband. You are going there to look at the facts, the evidence that the court brought before you. You're not supposed to gossip in there. You're not supposed to do this. So the judge will tell them the legal perimeter, the legal process that they need to go through so that their decision will be credible. That's what it means the judge charged them. It means the judge gave them charges already. They are supposed to be tried to. Then they go and decide some other case. So that's not it. Following, I'm still on page 2. Following deliberation, the court was informed through the jury foreman. Now, that's the important person you need to understand. The foreman of the jurors is the spokesperson. So, okay, many of all will understand it this way. The big man for all of them, the person who will stand and answer all questions from the judge. If they want to eat, that person will go to the judge and say, our people, my juror want to eat. If they say they want to drink water, they go to the judge. That person will be responsible. When they come from inside there while listening to the case and they have a question or anything to say, that person will stand up and say, Your Honor, my people here, my jurors here need to ask some question. Can we ask some question? That person is a spokesperson for them. Okay? So the foreman, then we go back there through the juror foreman that the jury had reached a verdict and was ready to return to courtroom to present it. The verdict was received from the foreman and, by order of the court, read in open court in the presence of all parties. The jury was thereafter discharged in keeping with established courtroom procedures. I need to open your mind on this. So when the jurors gave their verdict, this is how it happened. They are 15, so nobody was absent in this case because all 15 came in the court. So what the judge does is he go to Gibson Giroux. Gibson Giroux, the decision you made, is this your decision? Yes. Is this your decision? Yes. You said Samuel Tuena guilty? Yes. You say Tuena guilty? Yes. 9 people say yes, Samuel Tuena guilty. 3 people say no, Samuel Tuena is guilty. Is this your verdict? Yes. And then they retire them. They tell them, say, okay, now you are free to go home to your family, to your friends. You want travel, you can travel now. The case is over. Now what they mean by they were discharged, they were told to go home. Okay? They were discharged from their duty. So they were after the verdict, when they made the verdict, they left, the court told them to go home, and they all went home. And I remember they both stay home for 9 or 10 days, right? So let's continue reading. We don't want to waste time because we got only 2 hours. And so if I'll be explaining too much about this secret, the technical team, probably forgive me. I'm going to make it quick because I don't want to waste my time. Now the allegations of jury tampering or misconduct. While the court was preparing to hear arguments on a motion for the new trial filed by 3 co-defendants who have been adjudged guilty on some of the charges in the indictment, 3 individuals who have served as jurors in the case filed sworn affidavits with the clerk of this court on May 15, alleging jury tampering and misconduct. Upon receipt of the affidavit, and you will hear this always, sworn statement. It's just your statement. When they say affidavit, it's your statement that you stand by. Maybe some of you know what they call, notary. When you write statement, you go to the notary, they notarize the statement. That all they mean, affidavit. So that's any statement before the court is called an affidavit from the person. Yeah, this is what I want. This is what I said. This is what I stand by. That's an affidavit. You will keep hearing it. The court promptly notified all individuals and parties who have participated in the case of the complaints filed with the court. In light of the allegations set forth in the sworn affidavit, the court scheduled an investigation to commence on May 20th, 2026. We stay on page 2. Commencement of investigation. Following the citation issued by the court, the parties and individual invited to participate in the investigation appeared as directed, and the investigation commenced. Those present included the concerned jurors. Remember that 3 jurors that made a complaint. So they were the concerned jurors. They were the one that made a complaint. They were the one that they call concerned jurors. The lawyers of both sides, the defendants, the other relevant parties. The court then began interviewing the jurors, starting with 4 members of the jury panel. Stay on page 2 at the bottom of page 2. Stay order placed on the investigation. Now, they say stay order. It can either come from the Supreme Court or a court above or a request by one of the parties. So this time, somebody want their particular process to stop. So we're going to read that. On the second day of the investigation, Associate Justice, that we're going upstairs now. We're going upstairs. Now we are going upstairs to the Supreme Court. And there's somebody in chamber. Now, the Supreme Court, they don't operate the way we do our own operation. They are 5. Every time one person is in chamber to receive and decide cases that have nothing to do with constitutional matters. So they call them remedial rates like prohibition, certiorari, McDermott's, all the kind of rates, or any case, any issue arising from the lower court. Now, we are going to the Supreme Court. So the other party is running to the Supreme Court. On the second day of the investigation, Associate Justice Yusuf D. Kaba, presiding in chambers. I told you, issued a stay order based on a rate of prohibition. I told you about prohibition. It's a remedial rate. They call it remedial rate. Prayed for the counsel representing the defendants in the main case from which the allegations of jury tampering and misconduct arose. The stay was issued after defense counsel challenged this court's jurisdiction to investigate the allegations contained in the sworn affidavit. Now, let me say that small. I'll be very quick. So please forgive me if I'm fast because I just begged these people for 2 hours. And if I go beyond 2 hours, they will definitely charge me. They don't sorry for me. So I don't want to be in trouble. So the other parties, the defendant, Samuel Twer and others, their lawyer said, no. Your Honor, Usman Theka, you got no jurisdiction over this case anymore. The case is over. The jurors are gone home. The only case that you might have jurisdiction are the people who want retrial. But for us, for me, Samuel Twer and the other guy who were not guilty, you don't have any jurisdiction over the jury to bring them here again anymore. So we are going to go to the Supreme Court to tell the Supreme Court not to allow you to preside over this case. Your jurisdiction ended, so you cannot resume additional jurisdiction. So they went into the Supreme Court. Following the Supreme Court consideration, so the justice in chamber say, okay, I agree with you. Usman Theka, Judge of Kosi, stop right there. Don't go any further until I see what these guys are looking for. I see what they want. And so they put a stay order. A stay order means at it right there, wherever point it was, it remained at its criminal Kosi until the justice in chamber made a decision. Following the conference of the parties before the chamber justice, a mandate was sent to this court, accompanied by parties stipulation. Now, what is stipulation? Agreement. Anything that is a technical word I'll tell you today. When the lawyer says stipulation, it means this is what we agree on. This is what we do. This is how we proceed. So they agree on something. They made a stipulation. The mandate directed this court to resume jurisdiction over the investigation and to ensure that all parties were accorded due process consistent with Article 20A of the Constitution of Liberia. So finally, the Chamber Justice, Justice Kaba, said, you know what? The whole thing here, you lawyer from government, you can. Lawyer from defendant, you can. What you want? How you want for the thing to proceed? They say, well, this is how we want the thing to proceed. They say, okay, they agree on it. They say, okay, you'll go back. Judge, go ahead and start your case back. Take your jurisdiction. Resume jurisdiction and continue. And we are on page 3 now. The mandate of the Chamber Justice was assigned and read in open court. Thereafter, this court resumed jurisdiction over the case. Recommencement of the investigation and establishment of court's jurisdiction to investigate. Before proceeding further, this court must first determine whether it has the jurisdiction to inquire into the allegations set forth in the affidavits filed by the affiant. Now, when they say affidavit, the person who filed that affidavit is called affiant. Don't be confused. That's not a big word. So if you file an affidavit or you file a statement, they can't say statement. They will just say affiant. The court therefore notes that its authority to proceed with the investigation is grounded in a line of opinions issued by the Honorable Supreme Court of Liberia, including the following. Now the court said, okay, you know what? They told me to go ahead with this case, and I have authority. There are several cases that the Supreme Court of Liberia had decided that I can make mention as a precedent. And these things can give me the power to go ahead with the case. Now, case number 1 that the criminal proceed rely on to assume jurisdiction, the Republic of Liberia versus His Honor S. Jevon Smith and all. That was decided July 24, 2009. Othello Fangi versus Republic of Liberia at 42 LNR 74. Liberian Law Revised. This is one of the law book that we are using here. Elizabeth L. Macaulay versus James N. Doe, 22 LLR 310, page 310, or section 310. Anthony Bedell versus Quia Yin Howard, decided during the March AD 2020 term of the Supreme Court. Comer Liberia Corporation versus A.H. Bassman and Sons, 32 LLR 100. And the last one, which was six, there are 6 cases they mentioned: Shingin, Shaggin versus CFAO, 13 LLR 278. Now, these laws are the laws the judge said, look, these are the laws that give me the go ahead, that give me the authority to look into this case. And so I believe the justice in Chima also look at these laws and say, no, guys, the justice in the court, the judge of criminal code C still have authority to look in this case. So now the case will be, where investigation will continue. Having established the court jurisdiction to investigate, the court issued an assignment for the continuation of the investigation. The investigation was scheduled to recommence on June 16, 2026 at 10 a.m. In response to that assignment, all parties concerned with the investigation, either personally or through their representatives, appear in court for the continuation of the proceedings. Now, I want to make something clear here. When the Supreme Court Chamber Justice sent the case down for the Criminal Code C judge to take jurisdiction, there's something he said. He said, make sure that everyone has due process. That's a major legal perimeter in the entire jurisprudence in Liberia and most jurisprudence around the world. Due process. Due process means they must be informed, they must have the opportunity to read what the charges were, the conditions were, what the situation is. They must have the ability to respond to what they want to respond to, and all of that. They must be served with the information that they need to be served. The court must inform them. They cannot be in doubt. There cannot be any exculpatory evidence. Now, what is exculpatory evidence? Any evidence that is withheld by the prosecution that is intended to benefit the defense. It's called exculpatory evidence. Those things must be put right before everyone so that they can proceed. So now, we are still on page 3. The individual who were cited. Now, we want to know now who all participated in this investigation. So you want to know too. And I really wanted to know. So when I got this report, I was excited. Somebody from where Saudi Arabia sent this report to me. All the lawyers in Monrovia refused to give the thing here. I don't know how come. Because me, I knew in the town a little bit, so everybody just looking at me with some kind of eyeball. I said, okay, no problem. A friend of mine who is a lawyer all the way in Saudi Arabia decided to say, you know what, Gibson, I got this thing. Here is it. So I got it, read it. He and myself, we discussed the details. And he's a lawyer. He showed me some places where he had concern and everything, and I told him where I had concern. So here are the people that were cited by the court to participate in this investigation. The individuals who were cited appeared and participated in the investigation were listed below. Prosecution lawyers. How many lawyers from the prosecution attended? Here are the names, about 8 of them. Councillor Augustine Fire. I believe that some of you know as he should be either the county attorney or the solicitor. I'm not too familiar, so forgive me. Councillor Jared D.K. Galawolo. Councillor Richard Scott. Councillor Rudolph D.M.O. Johnson, Councillor Aliu Belete, Councillor J.F. Dexter Poyu, Councillor J. Adolphus Kanoa, my old friend. He's a journalist, but now he's a lawyer now. Councillor Joseph Sami. We are on page 4. In fact, there are 10 lawyers from the Justice Ministry. Councillor David A.B. Wilson and Councillor Boakai Harvey. 10 lawyers from the government of Liberia were on hand to proceed with this investigation. So, can we say the Justice Minister was short-handed? My answer would be no, because for you to have 10 lawyers from the government of Liberia, these are all counselors, not no Antonia Law. Antonia Law are people who just came from school and now they not reach, I think 5 years practice here for them to be able to, I think 3 or 5 years. for them to be able to take their bar test and pass. And now we're talking about Anthony. No. We're talking about counselor at law. 10 of them participated for the government of Liberia. So we can say the government of Liberia was well represented at this investigation proceeding. So defense lawyers, those lawyers who represented the defendant, how many of them? There were 4 of them that attended this process. The first person on the list was Counselor Arthur T. Johnson. The other person is Counselor James Coleman. Another lawyer is Counselor Bubusi Wamudiki. So this guy is a Nigerian Liberian guy. He's one of the smart lawyers around here. I know him very well. And then Counselor Francis Twan. So we got 4 lawyers representing the defendants, 10 lawyers representing the government of Liberia. Now, don't say that any bad thing. Don't jump and say, oh, but how can enough fair? No. The government of Liberia has a case to prove, and they have the burden of proof. They can like it, they can bring 100 lawyers, the defendant can bring 1 lawyer, it doesn't matter. But they have to bring their best to be able to convince the court and anybody present, or to put their heads together and come up with better legal premises, legal argument. And the defendant too, those 4 lawyers I'm naming here, those are crack lawyers. These are not small lawyers. Arthur Johnson, James Coleman. Everybody knows James Coleman. Mbudusi Mwambuduke. This guy was head of the, I think, LSCC before. So he's a good lawyer. Francis Twan, I know Francis Twan. I know his father. I know Francis Twan myself. I know him. So now there were other lawyers lawyers who represented other jurors, the 11 jurors. So the jurors too, no. He said, Your Honor, we cannot come here. We're not lawyers. So we got to bring our own lawyers too. And if they don't have money, the government can give them lawyers if they ask for it. I don't know what the situation was, what the arrangement was, but in any case, they were also represented by 2 lawyers. Their first lawyer on the list was Counselor Jonathan Massaquoi, represented the 11 lawyers that appeared, that they represented 11 or the 15 lawyers. The other lawyer is Anthony Wolman Sampson. So that 2 lawyers represented 11 lawyers. Then one more. The lawyers represented 3 Affian. Now, I got to separate them. 3 of the jurors made a complaint. So their case is completely different. So they had their own lawyer. And the person that represented them was Jimmy Sabombo. And Jimmy Sabombo is a great lawyer. I know him very well. He associated with the Gonglo movement before, so trust me, he's a robust lawyer. He's not somebody you can push over. So we got a very fair representation of these parties that are present, right? Now, don't jump in the gun yet. Don't jump in the conclusion. Listen until we get to the end, and then you can make an informed decision, because we are still in the beginning stages. This is page 4. Now, procedures established for the conduct of the investigation. To earn due process, tranquility, and order during the investigation, this court issued a 2-page set of procedures and guidelines consisting of 10 points to all individuals participating in the proceedings. Each participant or that participant legal counsel receive and sign for the written procedure and guidelines together with the affidavits filed with this court by the Affian. These documents establish the framework for the recommencement of the investigation on June 16. I told you due process was demanded by the Chamber of Justice. Now you see what the judge had done? The judge had to inform them what was going to happen. They received the procedure that was written that everybody would go by. The complaint that was filed by the 3 jurors, they give it to all of them so that they will be aware of what they are going to be looking at, what the complaint looks like, so they can be able to respond to the complaint, argue the complaint, and even take additional actions if they can. Due process is the number 1 thing in our jurisprudence in Liberia. If that due process is missing, your case you could win the case easily if the government or anybody fail to give you due process. So that is a very, very cardinal process. Now let's continue. Conduct of the investigation. Each affiant took the witness stand and testified regarding the contents of the affidavit alleging jury tampering. Thereafter, questions were received from the jurors, counsel, and the court. This procedure was adopted and applied to each individual who appeared as a witness during the investigation. The affiant were the first witnesses to take the stand. What does that mean? When they say affiant, again, I'm explaining it. The person who filed a statement, sworn statement. So those three people who filed a complaint, they are referred to as affiants. So anytime I say affiants, that the three jurors that made a complaint, consistent with the allegation contained in their affidavit, they testified that jurors secreted in the jury quarters had telephones in their possession. Let me pause here so you can know, so you can get something here quickly. Those three jurors are the jurors that voted against Samuel Twell. I want you to know that from the onset. So the three jurors, they told the court they are the one that voted against Samuel Twell. Those three jurors are the one that voted against Samuel Twell. They said, we have phone in our deliberation room. So it's like they went outside and they came out and said, even though I voted against Samuel Twell, but I have phone in there. So they are reporting themselves to the judge. They are filing a report and telling the judge, I want to report myself. When we're inside there, I have phone. We're not supposed to take phone there, but I carry phone. Okay? So in their possession. And that some jurors also carry multiple SIM cards into the jury quarters. They also claim that with other jurors that have SIM card. Now, I don't know what does that mean. Somebody get phone and other people get SIM card. What does that mean? I don't know. Whether the SIM card can talk with, can make call without the phone, or what is the importance of having SIM card there? Whether they put it in other people's phone, we'll see what the report said. According to their testimony, those phones and SIM cards were used to make and receive telephone calls and to send and receive text messages. Okay, so we now know that they put their SIM card in somebody's phone and they make calls, right? Notwithstanding the court's clear instruction and warning that jurors were not to take telephones into the jury quarters or use them during the period of circumscription. We explained circumscription already. The affiant further testified that multiple calls were made from and received within the jury quarters, and that text messages were received through the telephones and SIM cards taken into the quarters by several jurors. Two of the affiant, it means two of those three people that made a complaint. Again, I'm doing this so you can understand. When you're making your decision, I don't want you to make a mistake out there. Two of the three people that made a complaint, that's why I mean two of the affiants, Cynthia Sapler and Catherine Kwawa, testified that they used phone belonging to jurors Luce Mayanga. So Luce Mayanga had a phone. So they said, Cynthia Sapler said, Catherine Kwawa said, the phone that Luce Mayanga had, I use it. Janitor Bondu, the phone that Janitor Bondu had, I use it. Arnold Vincent, the phone that Arnold Vincent had, I use it to make calls to individuals outside the jury quarters. Now, what is the reason for this? I mean, this is my question though. I want you to think about this question. You were clearly told not to carry phone. You were clearly told not to take any device, communication device. But anyway, you took those phones anyway, and then you decide to make calls against the instruction of the judge in the jury quarter. And the former, don't forget, one of these people is the former. One of the women who complained is the former. Okay? So why will you disobey the judge's rule? We'll ask that question later. Catherine Kwawa further testified that she brought a phone into the jury's quarters in violation of the court sequestration instruction. She explained that while sequestrated, she used Lucy Mayunga's, on page 5 now, Mayunga's phone to call her boyfriend, Abraham Kangbe. Too many names are coming up. And Abraham Kangbe's name is in a public document, so we call it. That's not my business for him to appear in a public document. All criminal code documents are public documents. You can use it the way you want to use it, except you can't abuse it. So you don't be afraid. Any criminal case document is a public document. Civil matters are not easily public document until they are decided upon. So yes, to call her boyfriend Abraham Kangbe, and I schemed to purchase a phone and bring it to the courtroom. So Catherine said when she took Lucy's phone, the reason she used the Lucy phone for the first time to tell her boyfriend to bring her own phone too, because she see other people have phone. According to her testimony, she instructed Kangbe to leave the phone in the court's general bathroom. Can you imagine? They had to go all through that process. When you can't, don't come straight. Don't come straight to us. They will not let you. Don't go to security. Don't go to nobody. I don't want you to go. Just go in the bathroom there and leave it somewhere there in the bathroom. I will come and take it. That is the instruction she gave her boyfriend, where she later retrieved it and carried it into the jury quarters. Kwawa, which is Catherine Kwawa now, stated that after retrieving the telephone from the agreed location, she took it to the jurors' quarter and began using it along with other jurors. The other affiant corroborated means they agree with her, corroborated her account in sequence and reaffirmed their testimony during questioning by fellow jurors, counsel, and the court. We're still on page 5. In addition to the affiant, 12 other jurors took the witness stand, one after another. They consistently, I want you to listen to these things carefully. When you leave from here, after reading the thing, you go and lie to people. Don't say I said it to you. In addition to the affiants, those 3 people who testify, after they testify, 12 other jurors took the witness stand. After the two jurors that testified about the phone. 12 other jurors took the witness stand, one after another. They consistently denied that any telephone were present in the jury quarters and stated that they first learned of the allegation presence of phones in the quarters only after they were invited to participate in the investigation. Now, I want you to know now, so there's a contestable information now. The other 12 jurors said, the 2 people, what they said, or the other juror, what they said, that 15 juror now, 3 juror plus 12, that 15. So the other juror then, what they said they have phone, and Bupa will not see no phone. The 12 other jurors, they say Bupa won't see no phone. We ain't see nothing. All right? So let's go. We'll stay on page 5. Tampering with the investigation. During the investigation, it became clear that after the court issued assignments and summons for the recommencement of the proceeding, certain jurors met and agreed among themselves to undermine the investigation. Their alleged plan was to present a common position when called to testify, that no telephone were present in the jury quarter during the sequestration, and that no juror used a telephone with sequestration, while sequestrated. So according to the report now, the investigation, the first time they say somebody tried to tamper with the juror. So they say, okay, the other juror then, some juror, they say how many. Some of the certain jurors say, you know what, we'll go over there, we'll say, we don't see nothing. They made a plan. We'll go at the ice court, you see nothing. So that's what the court is saying now. To achieve this purpose, they began contacting fellow jurors in an effort to reach a consensus on their testimony. So instead of them keeping it to themselves, so they once they agree among themselves, won't go over there. They ask you, I see nothing. They ask you, you see nothing. Don't tell them say you see anything. So they start calling other jurors too. When they poke call you, say you don't see nothing yet. We go over there, we see nothing. They ask us, we see nothing. So that's according to the investigation report. In that connection, juror George Dennis called juror Catherine Kwawa and informed her of what had been discussed. So one of the juror, George Dennis, said, let me call Catherine, yeah, because she the complainant, she wanted the complainant. So let me call her while they put planning. Catherine, the other opponent say when they can't, they ask them, they will say they didn't see nothing. So your case that only your on the. So the poor already finish calling all, they say we must go there, we must say we see nothing. I put in the elaborate English now so you can understand. Okay? Catherine, and inform her of what had been discussed, namely that each juror should testify that there had been no telephone in the jury quarters. Juror Dennis was unaware that his conversation with Catherine Kwawa was being recorded. So that's another thing. Whether it's legal or not legal, the judges or the lawyers know. So I'm not going to delve into that. You talk to somebody between two of you, they may record you, he didn't tell you recording you. In other jurisdiction, it's legal. In other jurisdiction, it's not legal. But in the states, between you and myself, I record you, I can use it because it's you and myself conversation. I can use it as proof. So in other states, it's not permissible. In Liberia, I don't know what is it. So I'm not a lawyer, therefore I cannot say anything about it. Catherine Kwawa testified that on the eve of the juror's appearance for the investigation, she received a call from George Dennis. According to her testimony, Dennis informed her of what had happened, what had been discussed at the jurors' meetings, and what they had agreed to say in response to questions about the presence of telephones in the jury's quarter. Now you gotta notice something here. These people were already home. They were already home. They've been home for 9 days or 10 days. You can give and take. Here now, they call meeting in their community, in somebody's house, in somebody's bedroom, in somebody's living room, someplace. They call their meeting. They can now call meeting and consult. So they called their meeting and consulted among themselves to say, we didn't see nothing. The judge asked her, we didn't see nothing. You see anything? No, okay. That one must say, won't go ahead and say that what Catherine told the judge, and she didn't do that by her mouth. She recorded George Dennis. So when George Dennis called Catherine, he ought to have known that Catherine, you don't know where Catherine's sitting down. Whether Catherine get two phones recording with one or she get recorded on her phone, you don't know. So he called and Catherine recorded him. And Catherine probably did not even tell him that he recorded him. But the judge did, the investigation did say so. When asked by the investigation to explain the conversation between him and Catherine Kwawa, George Dennis stated that he was surprised and disappointed that what he considered a private conversation had been recorded by Kwawa and used as evidence against him. When further asked whether the voice on the recording was his, he answered in the affirmative. When somebody say he answered in the affirmative, it means the person said yes. When they say the person answered in the negative, it means the person said no. In other words, they asking, did you call Catherine? Yeah, it's your voice. Is this voice yours? Instead, he was surprised that he called Catherine to discuss a private matter and Catherine recorded him. Well, that's why you should be sensible when you are dealing with people. Smart. I always tell people it's a difference between being smart and being wise. Some people can be smart, but they're not wise. Okay? So Catherine recorded him. Now his voice is being put right in front of him. Is this your voice? Yes, sir. That's my voice. Let's continue page 5. At the bottom of the page 5. The investigation views George Dennis' conduct as tampering with the investigation and its outcome, and with the intent to conceal material evidence. Well, they are case in case now. So they're not defending or prosecution tampering the jury now. That jury tampering with jury now. So that different case now. And that one I'm going to A. And they say what George did by calling Catherine and discussing these things is mean that he tampering with jury. He tampering with the investigation rather. So that different one there, that one they will decide what they want to do with Josh. That's another thing. Juror Arnold Vincent's claim of home burglary and stolen phone. So one of the jurors, Arnold Vincent, remember the three jurors that made a complaint? So Arnold Vincent. So let's go to page 6. Upon reporting for jury service, Arnold Vincent informed the court that his phone had been stolen the night before during a burglary at his residence. According to Vincent, both the phone and the SIM card were taken by the burglars. Burglar means those who burglarize the place. On that basis, he made a formal request for the court to write to the bank so that his wife could access his bank account while he was away on jury service. The investigation later found this account to be untrue, so he lied. He lied to the investigation team. He lied to the court. He lied to all the lawyers. He said, you know what? Before I came to the jury team here, they rode and went there and stole my phone. They stole the SIM card. They stole the phone. So I asked the judge for my wife to go to the bank so she can get some money from the bank. All that thing that lied. They're not true, according to the investigation. Vincent's SIM card and all telephone numbers, which have been registered with jury management, appear among the numbers used to make and receive calls and to send and receive text messages during the sequestration. When you go to the court as a juror, when you turn your phone over, they register your SIM card and they register your phone. All that thing, I know how some people can forget. You know he did that, then he low lie and say the post stole your phone. Not knowing, the post say, no, that's not true. You brought your phone card, we brought your phone here, you brought your SIM card, yeah. We got record for A. So he lied. Let's continue on page 5. Continue on page 6. Page 6. The investigation therefore finds that Vincent's claim that his phone and SIM card had been stolen was a deliberate attempt to mislead the court. The claim appears to have been intended to conceal the plan to take SIM cards into the jury quarters and later use them to contact unknown persons, contrary to the instruction issued by jury management in the court. Nothing from the talk there. The investigation further finds that Arnold Vincent's conduct, beginning with his declaration that his phone and SIM card had been stolen, was deceptive, deliberate, and intended to evade the rules and regulations issued to jurors during the after jury orientation. The investigation also notes that similar conduct was exhibited by most of the other jurors who appeared and testified during the investigation. Nothing for me to say there. I continue. Sir Jonathan Bondo, the call log analysis show that this juror, Sir Jonathan Bondo, I want you to note that there's a special person here, Sir Jonathan Bondo. The call log analysis show that this juror began making and receiving calls on the same Lone Star number, MTN number. The number is 0880 812 054. Now, it is public record. You can check it if you have the expertise to check it, who the number for, who is it going to, but they say the number for him. So it's 0880 812 054. Before reporting for jury service and continue to use that number during sequestration. The analysis further show that while sequestrated in the jury's quarter, he made calls to 23 individuals outside the jury quarters. Notwithstanding this evidence, the juror denied using or seeing any phone in the jury quarter during the sequestration. Okay, he called 23 people. Now, I got a question here, guys. And the question, you can't answer this question. We will read. If this question is answered by this document, I will be glad. And I'm not going to tell you whether I answer or it doesn't answer. The question is, if this man talked to 23 people, and they are talking about jury tampering, with the court, with the case, does this court have interest in bringing these 23 people in to ask them what did they say to jury Sir Jonathan Bondo? Will you have the same opinion as I am that the court or the prosecution should file a motion to subpoena these 23 people, send a note at 23 people, and take these numbers, go to MTN, trace them, bring them in before the court for them to say what did they discuss with Jonathan Bondo? Because Jonathan Bondo has already started lying that he don't have any phone at all. So I wouldn't be surprised if you say they didn't discuss anything about the case, right? Okay. So nothing was said about Jonathan Bondo about the case. But did the court find out these 23 people, whether that just family matter they were talking about? Because we don't want to leave tomorrow and say, oh, one of these 23 people were talking about Samuel Twe. So now it began who say, what say, and then we the whole thing is muddy. So that's the question I'm asking. Lucy T. Mayonga. Juror Lucy T. Mayonga. Lucy T. Mayonga denied using or seeing any phone in the jury quarters during sequestration. Contrary to her claims, the court law analysis showed that she had an orange mobile number 0775 864 936 0775 864 936 with her in the jury quarters and used it to make calls and to send and receive text messages. The analysis further showed that other jurors used Lucy Mayonga's phone, to call individuals outside the jury's quarters, which is consistent with the allegation made by Catherine Kwawa and Cynthia Tapla during the investigation. So also, Lucy also did not tell us the truth. She said she did not get any phone, she didn't do any call, but we realized that she made calls. Maximum DeLong. I don't know who the person is, Maximum DeLong, that's the person name. The call law analysis showed that Maximum DeLong used phone belonging to Catherine Kwawal and Lucy Mayonga to call his wife at 0776 525 059. Oh, this number is also different from Lucy's previous number. So we have so many numbers in there. This evidence contradicted DeLong's denial that he used or saw phone in the jury's quarters during the sequestration. DeLong say, that thing you're talking about, I see nothing. But when they go check, he said make call too. Call logs summoned by court. Now we get into business, right? The court now want to see how many people may call and who may call. So we want to call logs now. In light of the allegation that jurors possess telephones in jury quarters and use them to call, to make and receive calls and text messages, and in view of the jurors' persistent denial that any phones, page 7, that any phones were present in the jury's quarter, the court sought to verify and authenticate the competing claims. To that end, the court subpoenaed the telephone records of all jurors and lawyers, all the lawyers who participated in the case. Now, that's an interesting thing. I'd like to see more of this that was just read. They asked for all the call logs for all the jurors and the lawyers who were in the case. That means Samuel Twe lawyers and the government lawyers, all of them, their call logs were invited. Now, we're going to know if Samuel Twe ever called or his lawyer ever called and say, please don't vote against Farmer Twe. So we're going to know, right? We expect to know, because if they make a call, we know, the court will know. But let's read. 2 GSM companies providing mobile telephone services in Liberia were ordered to submit the relevant records to the court. Orange Liberia Lone Star MTN subsequently produced hundreds of pages of telephone records, which the court reviewed and analyzed with technical assistance and support from representatives of both companies. So the two companies, Orange and New Star, the court definitely you are looking at the thing here. If you want help, we can help you. Yeah, you're trying to help, but I don't know the thing here. So they help them to distinguish all of these things to go through it. The analysis show that numerous telephone calls and text messages were made and received by jurors while they were sequestrated in the jurors' quarter during the trial. Annexed to this report are detailed breakdowns identifying the jurors who made and received calls and who sent and received text messages from within and without the juror quarter. The annexes also indicate the relevant dates, numbers from which calls were received, total call duration, numbers that sent text messages, and numbers that received text messages. So there was an annex that is to this document that show who called, where they call, how long they talk, and all of that. Findings. Oh, we come to the major point. I want you to take notes. If you have a pen, it's time for you to bring a pen close to you. Findings. The investigation findings. What did they find? After thoroughly investigating the jurors and analyzing the cell phone records of each juror, as well as the records of other persons of interest identified during the investigation makes the following findings. 1. The call law analysis show that multiple cell phones and or SIM cards were taken into the jurors' quarters by jurors and used to make and receive calls and to send and receive text messages during the period of sequestration. So it is established that it's true. There was cell phone in there, there was SIM card in there. Not only that, but people make call, people send messages, people receive messages. But let's go further. What the finding further say? 2. Most jurors took cell phones and SIM cards into the jury quarters despite clear instruction that they were prohibited from doing so. Okay, we're still on the scene taking phone there, but this one now is modified that they violated the judge's prohibition or the judge's instruction. Don't carry phone in there. Don't carry anything, device, anything in there. So that's the second layer. Now listen. So we know that they call. I'm looking for something. I want to see something. I know you want to see something too. You want to hear something too. So they know now that there's call. They talk to people. So we want to see what the findings got. Number 3. The number 0886 500 698. That's another number that was used during the jurors' deliberation. The number 0886 500 698 contacted almost all of the jurors during the period of sequestration and also contacted relatives of jurors. Now you and I have major questions to ask. If this number, now I'm going to put you in a frame of thinking. They said, this investigation said, the number 0886 500 698 call all the jurors. Not only that, they call jurors' family members who use that phone. I want to see in this report, you want to see also in this report, because that should be the business of the investigation, who used this phone to call the jurors. Who number is this? And when they call the jurors, when they call jurors' family members, they could bring the jurors' family member to ask them, when you were called, what did you hear? Was the prosecution who was pushing this case interested? I'm asking questions. I'm not answering any question at this point. I'm just provoking your thoughts. What do you think? Number 4. Now, number 3 is one of the major questions lawyers are asking. After I received this report, I begin to make calls to a few lawyers that I know. And then they asked me to read the findings. And I said, do you have any question? The first place any lawyer I called, they didn't go to question the finding number 1. They didn't go to finding number 2 because they are very clear, very unambiguous. They are completely clear. Don't carry phone, you carry phone. That's number 1. We told you not to carry phone, you disrespected our rule. Number 2. Number 3 raises the first fundamental question. This number, 886-500-698, call all the jurors. Call all the jurors. It also called juror families. But let's go to number 4. Number 4. The number 886-500-689. Now, can you imagine? Same kind of number, only the last 3 digits are different. I don't know if they made a mistake or they didn't make a mistake. I'm not going to tell you whether they made a mistake. In my view, they made a mistake. In my view. But again, that's not my place to say they made a mistake. Because the first number was 698. Now they have 689. I believe it will be 698. But I will take it as that. But because I'm reading and some of you are not seeing it, therefore I'm going to give it to you just as is. The number 866-500-689 was in regular contact with most of the jurors, primarily through text messages. So, guys, when you send text message, it stick. It don't go until you erase it. And there are technical people who are IT people who can still recover a missing text message. Did the government have interest in getting the text message? I'm raising another question, group of questions. That's another question that lawyers raise. If the government is so interested in having this conviction or this acquittal overturned, can the government be interested also what was in the text messages? Who sent the text message? What did it say in the text message? Because if somebody just sent me and say, my daughter, please, I got small money in the cover there. Go and take it and cook food for you and your friend, your children, your little sister there. Well, that kind of message has nothing to do with Samuel 12 case. Therefore, nobody want to care about that. But if that same text message say, look, Samuel 12, y'all know now that our man. So y'all know what to do in it. That kind of message, you definitely want to be questioning that message, right? So if I were a government lawyer, I would be very, very interested. Very, very, very interested in what the text messages said. But let's read on. So I read up number 4 again from the beginning. The number 886-500-689 was in regular contact with most jurors, primarily through text messages. The number has been subpoenaed, and the true owner must be identified and subjected to investigation and penalties. Can you imagine? Look, for the first time, I would say this is the most stupidest comment I've seen in an investigation report. And I'm passing judgment on this particular sentence. Because if I were part of this investigation, I would never come to this point and write a nonsense like that. An investigation committee goes to investigate. They find a number and they say somebody else will investigate and bring the person to book. The court is investigating a case that is going to determine other people's life. Then that same investigation committee says, we got a number here, it call everybody, it send message to everybody, but let somebody investigate a number and determine who owned that number, and when you find the person, you must punish the person. Who will do it? Who is going to do it? So one lawyer called this a stupid legal premise to disturb the judicial system. A stupid legal premise to disturb the judicial process. You've been investigating, then you want another person to investigate a number that you're supposed to investigate. I want you to keep that because we'll come back to that. That does not mean, though, let me be clear here. That does not mean whether the process is against Senator or is not against Senator or against government or not against government. I'm saying, Gibson, I will not be an investigator of an issue, see a number that call almost all the jurors, that send messages to all the jurors, and I did not find who that number belongs to, what the messages are, and I'm recommending to the court that you must try and investigate the number, and when you investigate the number, you must punish the person when you find the person. I should be telling the court who the person is and making recommendation what the person penalty should be like, or even if I make a recommendation and show the person and what the person said. That's what I need to do. Why will you come and for them to form a new committee? But let's read. Did they identify the individual or not? You will see why I'm making the comment. Let's go to number 5. Findings number 5. Jurors General Bondo, Arnold Vincent, and Maximum DeLong coordinated telephone calls and text messages between persons outside the jury quarters and jurors inside the quarters. Again, I want to see in this report, I want you to mark it down. Finding number 5. If Jonathan Bondo, Arnold Vincent, and Maximum DeLong coordinated and sent messages, they are read before the court. 2 things the court can do, or 3 things. 1, bring your phone. Let's check the messages. Let's assume they will delete the message. And you must start thinking the same way. Don't think I'll forget that. Maybe they deleted the message. Okay, who you texted? Let's find the person you texted. We trace the person. Maybe the person also deleted the number. The text messages. The last option is to bring experts from the 2 companies, MTN or Lone Star and Orange, and let them retrieve the text messages and bring it before the court for the court to read. Because we can't be in doubt. We can't say messages were sent and we don't know. Then we be guessing all over the place what the message say. Maybe that somebody beginning that sent a message. Maybe that the government people that sent a message. Maybe they were telling the people to do this. So why should we be in doubt when we went to investigate to clear our doubt? That's another problem I have. Number 6. Finding number 6. Now we are on page 7. Don't forget, we are on page 7. Other telephone numbers also appeared in the call logs of certain jurors during the circumscription period, either as numbers that called jurors or sent text messages to them. Those numbers have been subpoenaed from the relevant mobile company for analysis and for any further action consistent with law. All right, so they just subpoena them and they want to analyze them. Okay, so finding number 7. Jurors discuss the case among themselves on a daily basis while returning from court, while riding on the jury bus, and while in the jury quarter. At certain point, disagreements arose among them based on positions taken in the case. Now, I have something to say here quickly. So, I want to know why this is and the finding, and if it's an important finding, was there any instruction by the judge that when they in their bus, because only they alone in the bus, that they cannot discuss the case, that they cannot disagree, because that's their boss. They are only them in the bus, or because the driver is there, therefore they cannot talk about it. Were they banned? We don't see anything that tell us that. But let's read and see whether they were told not to. But for this particular number 7. Finding number 7, it leaves us in doubt more than provide solution to us. You can't just say something and leave it hanging and leave us thinking all day and scratching our heads. Were they told not to discuss this case in the bus? How is it important for you to tell us that it's a finding? Were they told not to discuss in the bus? Were they told not to argue in the bus about the case? Were they told not to disagree with each other or agree with each other in the bus? We want to know what make the particular number 7 very important. Let's go to finding number 8. A majority of the jurors were untruthful about their knowledge of phones being present in the jurors' quarter during the sequestration. Well, yes, I mean, this is a very, very great, open, and clear finding. Number 9, most jurors met before the recommencement of the investigation and agreed to maintain a common position that no phone had been present in the jurors' quarter during the investigation. Well, that's a good finding. We're also clear because they plan it that when we go over there, when they ask you, what you will say? I see no phone. Me, that what I'm going to say too. No phone. I see no phone. That one, they can tell me also dance. They're not going to be poor word my more and take word from there. I say nothing. So those are kind of things they plan, right? Finding number 10. Jurors Catherine Kwawa. Now, I want to say here, my understanding is Catherine is the former. My understanding is Catherine is the former. She was a spokesperson for the jurors. If I'm mistaken, if you call, let me know. But my understanding was Catherine was the former of the juror. That means she was the head of the juror. He was the spokesperson of the juror. But let's leave it at that. Let's just use her name and leave it at that. Jurors Catherine Kwawa and Cynthia Tabler remain consistent with the account contained in the affidavit, which the investigation found to be true and accurate. By contrast, other jurors continue to deny the presence of phone and SIM cards in the jury quarter. Number 10 is a beautiful finding, to be honest with you. It's a beautiful finding, even though I have a little question here. I'll have a little comment here. Catherine is one of those who voted against Samuel Tuer. Cynthia is one of those who voted against Samuel Tuer. Catherine and Cynthia, they're the one, after they went home and stayed home 9 months, they told the prosecution and say, hey, we don't want care phone down there, that we don't want violated the judge order. In fact, plenty of all have phone there said. So they made a report. Now I'm going to read you a legal premise in the common law based on a research that you cannot create a trouble and benefit for the Listen, guys. Listen, let me just make it simple here. And I don't want you to think negative about this. I want you to just think how things happen in the real world. So you and your brothers, you're 3. Your pa told you to go and buy the Grampy. While you're bringing the Grampy, your little brother went and stole the Grampy. And then, when they went to the pa, they tell the pa, say, our brother, he the one make us to take the Grampy. I the one took it first. So, anyway, let's not waste our time. So I'm saying those were people who voted against Samuel Tuer, and they are the one that came and say, even though they voted against Samuel, we don't want we don't want cause the trouble. We don't want carry phone there. In fact, we saw other people phone too. So they the one coming clean now. All right, let's go to finding number 11. Juror Sia Tandapoli alleged that now we have somebody named who is a lawyer. I want you to listen to this. Juror Sia Tamapoli alleged that Councillor Augustine Fire, one of the lawyers for government, the number 1 lawyer for government on the list, and Juror Foreman. Okay, so Catherine was not a former. Catherine was one of the jurors. The former was Harriet Toba. Now let me read that very clearly for you to listen. So Harriet also voted against. She was the 3rd juror that voted against Samuel Tuer, and others who were acquitted. So let me read it for you. I want you to listen to this because I want to be as clear, as honest, as unbiased as possible. Jurosia Tamapoli alleged that Councillor Augustine Fire, the number one lawyer on the list for the government, and the juror 4 lady, the woman who was a spokesperson for the juror, who was leading the jurors, Madam Harriet Togba, were involved in a romantic relationship. So, the man who is prosecuting Samuel Twer, the government prosecutor, chief prosecutor, who is prosecuting Samuel Twer, is now being accused that his girlfriend was the full lady or the leader or the spokesperson for the jurors. If the judge had a magic wand and determined and was able to know whether this was a situation, I think the judge was going to tell us, don't come close to the jury pool. The man who is prosecuting someone, his girlfriend, is the leader for the jurors who's supposed to decide people's fate. That's what one of the jurors said. After following up on that allegation, the investigation, well, of course, she was unable to provide enough evidence to that. After following up on that allegation, the investigation found no concrete proof or evidence to substantiate it. Of course, there's no evidence. She don't have their text messages. She don't have their phone. She was not there when they were making love. She not in Harriet's house for where Augustine go visit or sleep, or to go to Augustine's house to sleep. So probably they ask her, what evidence do you have? She say, I don't get nothing, but I know that they love me. Even for it to come out, it's a sufficient reason to create doubt for me. If you don't create doubt in that for you, then it is for me. And that doesn't mean that Samuel Twer is right or wrong, or the government lawyers are wrong or right. But I'm saying it's a red flag for me that somebody will accuse the prosecutor, the chief prosecutor, of having leaked or romantic affairs with Harriet. So the question then is, if the court was asking for evidence, is it possible? Could it have been possible that the court will summon the record, the full record of juror or full lady Harriet Togba to see whether there's any text message, romantic text messages, or number of calls from Augustine Fire to her that would be suspicious? Could it have been that the investigation would have gone a little bit deeper to find out? Of course, in a court of law, but there's an investigation. Of course, in the court, but it's an investigation. They say the accuser has the burden of proof. So they treated it on that level. You accuse the Augustine Fire and Harriet, you have the burden of proof to all that they are actually loving. And once she didn't have any physical evidence, they kick it aside. They say, no proof, no evidence. So we pass it on. So we leave that. Finding number 11. I want you to be clear on this. I have my doubts, I have my questions, and which is why I brought this to read here. Of course, I will always make a stand, my position clear on legal matters that are not something for you to say, oh, at this I won't be biased. No. You got to state what your opinion is, even if you disagree or agree. And that doesn't mean that you disagree so you're right, or you agree so you're right. There are other lawyers or better people who can read it and make a decision. So let's move on. Finding number 12, which is the last finding. Following an inspection of the jury quarters, the investigation found that garbage generated by jurors doing sequestration, including debris from phones or SIM cards, have been disposed of by the juror themselves without any traces. So these jurors, they were very, very smart. All they did, all the day, when they open the SIM card, right? The SIM card can be in little plastic. They all I wanted when they open SIM card, all I wanted, they throw everything away. The judge was not able to see anything. We stay on page 7. Conclusion. Following a rigorous investigation process, the investigation concludes that there is clear evidence of jury tampering. Now, I want to read that one more time. Following a rigorous investigation process, the investigation concludes that there is clear evidence of jury tampering and jury misconduct. For clarity, in the investigation want to make that clear for all of you. You don't want to leave you in doubt here. For clarity, the two concepts are related but distinct. Now they want to separate the two, misconduct and jury tampering. So they want to distinguish that. Jury tampering involves an improper attempt to influence, manipulate, intimidate, or bribe a juror during a legal proceeding. That's jury tampering. Again, let's look at the words that define jury tampering. When you arguing at the Atai shop, or you are in your class, or you are at the Palava Hut, and you're discussing, you want to be very clear on what you're looking at. Jury tampering, there are few words that define clearly based on the lawyer's perspective. 1. It is an improper attempt to influence that juror to make a decision in favor or against. To manipulate the juror. To manipulate the juror to make sure that the juror do something that will not normally do. To intimidate the juror and say, hey, look, let me tell you something right now. I'm just putting on the government side, but that doesn't mean that why government did. I want to be clear on that. Because that the government can able to do something for me to be afraid. Plus, defense can't tell me that thing I be afraid. So I just giving you something so you can know why intimidation is. So let's say the prosecution lawyer, the county attorney call one of the jurors and say, look, that case you're going on, you we got something on you. When you now vote for somebody to be convicted, we jail you for a good number of years. We go and say you go in there, you not vote to convict come to it. So you intimidate the juror. Okay? Or even the defense can do that too. The defense lawyer can say, you know what? And I know that you're loving to the prosecution, the lead prosecutor. And if you not go there to vote in favor of Samuel Twe, I'll tell everybody that you were loving to the prosecutor, and then you'll be exposed. Those are intimidation. Okay? So you got to be able to influence the juror. You got to be able to manipulate the juror. You got to be able to intimidate the juror. Or you got to be able to bribe the juror, offering money and material thing to the juror to change the juror decision during the legal process. Such conduct is intended to undermine the judicial process and violate the constitutional right to a fair and impartial trial. It may occur both inside and outside the courtroom. So in other words, somebody can influence the juror or tamper with the juror inside the court or outside the court. Jury misconduct. Now, what is jury misconduct? Let's look at jury misconduct. By contrast, refers to conduct by a juror that violate court rules. So don't care phone inside there. You care phone. It's not tempering. That misconduct. That violate the court rules, judicial instruction, or juror's oath. They say, don't call people from inside there, you call people. Don't carry phone inside there, you carry phone. Don't eat inside there, you carry food, you eat. When you in a jury room, don't leave and go talk to people outside and come. You go talk to people outside and come. Those are misconduct. Jury misconduct, by contrast, refer to conduct by a juror that violate court rules, judicial instructions, or the juror's oath. Such misconduct may compromise the fairness and impartiality of the trial and may result in a mistrial and setting aside of the verdict. This is where the debate is. So the investigation team set a premise. They say a misconduct happened. It can cause the trial to be mistrial. In other words, the trial got to be done again. Or when somebody was guilty or not guilty, they can say, well, that thing that happened, the juror then our conduct were not correct, so we are disregarding that verdict. We are disregarding that verdict. Or the removal of the juror, of the offending juror. Example include premature deliberation. You cannot talk about the case when the case is happening. Premature deliberation. You can be gathering somewhere and discussing the case as if to say the case already finished. Can't do that. Or discussion of the case before the close of evidence and before the court authorizes deliberation. So you can't do that. So I see the reason why finding number 11 was inserted, that they were in the bus and they can be talking about the case in the bus. They can be discussing, they can be agreeing or disagreeing with each other in the bus. So that's what number 11 is for. And that's the question I'm asking. Was there an instruction? So it is the misconduct by the court's rules, by the court's definition, that you can't be discussing the case before the case is over. You need to keep quiet. Don't talk. Don't say anything about the case until you go in your jury room. The judge charge all of you. You go to your jury quarters and you discuss. Then you put any discussion, any disagreement you have, you can put on the floor. But you can't be in everywhere and just be disagreeing or be agreeing and then be discussing it. A court authorized delivery, and as well as concealing biases or bias during jury selection or void dire. Now, void dire. I want to explain this because these are court issues. I'll give you an example. The allegation by the other lawyer that Harriet Togba, the juror's spokesperson, was the girlfriend of Augustine Fire, Councilor Augustine Fire. That was the allegation, right? That kind of allegation, what the investigation is saying, the court is saying here, Harriet is under responsibility doing jury selection when they were selecting the jurors at the time to say, I am the girlfriend of Augustine Fire. He and I were in a relationship 10 years ago, 5 years ago, but we are no longer in relationship. Something like that. I'm not saying that's what happened now. Something like that. You need to explain, you need to disclose your bias. You can also say, Simon Toer is a good friend of mine. I helped him before, or he helped me before, or usually we meet at a club, or we usually meet at my auntie place, or we usually eat dinner together. Or you can say, the lawyer for Samuel Toer, Arthur Johnson, is my in-law. He married to my sister, or my brother married to his sister. Those kind of information need to be, because these kind of thing can create biases. So the court say, look, if you have something like this, or I personally, I don't like Samuel Toer. In fact, I already believe that he's guilty. I just here for me to just confirm it. You got to be able to disclose your bias. Okay? That's what they're talking about. And everything I said does not mean that's what happened, but I'm explaining what the code mean by you should explain your bias before you can be selected. Let's continue with the conclusion. Notwithstanding the juror's persistent denial that they possess or use phone in the juror's quarters or saw any juror with a phone during the secretion, the evidence established otherwise. The investigation found that several cell phones and multiple SIM cards were present in the jurors' quarters as alleged by the affiants, and that jurors used those devices to make and receive calls and to send and receive text messages to and from individuals outside the jurors' quarters. The investigation further concludes that the allegations of a romantic relationship between Councillor Augustine Fayad and Harriet Toba was not substantiated. The court did not say it's not true. I want you to note that the legal language they are putting there. They say it was not substantiated. That means she didn't prove her case. Because she has the burden to prove that what she said is true. There was no evidence to show that, to convince the court that yes, the Harriet and Augustine Fayad were loving. She did not substantiate her allegation by evidence and serve as a distraction from the central issue on our discussion. Recommendations. I want you to listen to these recommendations. They're very interesting recommendations. Based on the evidence received during the investigation and after careful analysis and scrutiny of that evidence, this court makes the following recommendations and decision. 1. The entire jury panel secreted to hear the evidence in a case from which the affidavit arose is hereby ordered arrested forthwith for contempt of court, incarcerated at the Monrovia Central Prison, and turned over to the Ministry of Justice for prosecution for gross jury tampering and jury misconduct. I disagree with the decision, and here's my disagreement. It will be double punishment. When you commit a crime and you are punished for the crime, then they gave you another punishment. For me, it will be like double trouble that they are putting you in. So they already held them in contempt and they are in jail. And the court is saying the Justice Ministry should prosecute them again. So when they prosecute again, they guilty again, then they go to jail again. I think this is stupid. I don't think it makes sense to me. I think that, in fact, just because I'm not a lawyer, so I will say what I want to say and let lawyers disagree with me. I can put this in the position of a double jeopardy. I don't think it's fair to them. If you already hold them in contempt and punish them for their action of violating the judge's order. But at the same time, after you hold them in contempt and send them to jail, we don't even know how long they're going to stay in jail. Whether they're going to stay there 1 month, 2 months, 5 months, 1 year, we don't know yet. So when they stay in jail, when they leave from in jail, then the Justice Minister prosecute them again and punish them again for judge to jail them again. I don't think it's fair, and I disagree with recommendation number 1. And you can agree, you can say, Gibson, what you saying nonsense. I think the judge is right. That's your right to say that. But I have to make myself absolutely clear so you know where I stand on the issue tomorrow. When they see issue come, they say, well, Gibson said this was wrong yesterday, and we refused, and we said you were talking nonsense. Now we know that Gibson was right. Or Gibson said that the other day, we said he was right, but he misled us, he was wrong. You can also say that. Let's go to recommendation number 2. The persons associated with telephone numbers that may cause to receive calls from and send text messages to jurors while the jurors were sequestrated shall be identified, arrested, and prosecuted together with the jurors for jury tampering where supported by the evidence. Complete nonsense. I'm telling you now. Complete nonsense. And I'll tell you why it's nonsense to me. Recommendation number 2, they are abdicating their responsibility. Oh, why are you speaking being against me? The old man is listening. What you call abdicating? They put getting job to go to the bottom of the case, but they went and left the case some kind of way. They are making recommendation for them to set another group of people to go and find the people who got these numbers, who own the number and who they call to. Complete bogus. I don't think It is a fair process, and I don't think they clarify our question. They should have been able to go deep into that and find who the numbers have. Listen to the reading. Somebody writes something that they put who are educated people. In fact, they educated more than me 5 times, 20 times. Why would they write some nonsense like this? Let me tell you, let me read what it said. The persons associated with the telephone numbers that make calls, receive calls from and send text message to jurors. They're not the jurors they're talking about that had telephone. The other people outside the jury, outside the court, the other people in the community who were calling the jurors. And they said they should be identified. Who should identify them? We gave you a piece of job to do, and you come back and tell us, oh, you're here, you will go and find people and find them and then prosecute them, arrest them. You should find them. You should tell us to arrest them. You should tell us who are they. You should tell us what they said. You should bring them before the court to defend themselves about what they have done. You should bring them before the prosecution and the defense lawyer to ask the question, what did they say? Why they said that? Why they called the juror? Was it important? Was it death and life issue? You should do that. But now they are making recommendation that the court should make sure that these people are identified, they are arrested, and they are prosecuted. Who will do that? That's why I say it's bogus. It's nonsense. This is part of the report that will never receive my commendation. And other places I praise it. But this one, complete nonsense. You disagree with me, you agree with me, let me know when I open the phone line. Recommendation number 3. The evidence having established gross jury tampering and misconduct, and the jury's conduct having contaminated and tainted the verdict returned on May 8, the trial from which the verdict arose is hereby declared a mistrial. The verdict is accordingly set aside and a new trial is ordered. This is where the argument is. Recommendation number 3 is where the problem is today we stand. The recommendation, the committee could not be able to find those who make calls, but they are making recommendation that the entire case should go to retrial. Every decision that was made, it should be dismissed. Any verdict that was made, those who are guilty and those who are not guilty, everybody go back to square one. If you want to make that kind of recommendation, you damn well get to the bottom of the case. Go after those who have the telephone number, bring them in because they cause trouble. They are responsible for calling in. They made a juror tampering to suffice. But you are leaving it with us that we should go investigate. So why don't you wait? We investigate and find these people and come back to the bottom of the case before we can come to the recommendation to declare the case mistrial and to go back to square one. You see where my problem is? So if you're going to leave something with us to find out, if you're going to leave something with the court to do additional investigation, or the justice minister to do additional investigation, additional arrest, additional prosecution, then why you can't wait when they do that? Then before they can go back to square one and say, okay, now we know now that those people who call from outside, they interfere with the court, and so therefore let the case go back to square one. You left a job with us to do. Now you want the whole case to go to square one. That's where my problem coming from now. So let's see how you disagree with me. Recommendation number 4. The clerk of this court accordingly ordered to prepare commitment, place same in the hands of the sheriff of this court, commanding her to arrest and detain all 15 jurors at the Monrovia Central Prison pending the outcome of their prosecution by the Justice Ministry, and it is hereby so ordered. Another bogus. Look, guys, I'm not a lawyer, I'm not a judge, so my opinion is free fall. I don't care how they feel about me, but this is complete nonsense. The judge is going to jail somebody without a timetable? Do you people agree that the judge is going to jail somebody on contempt without a timetable, without a limit? Do you guys agree to that? that those jurors, those 15 jurors should be in jail until the justice ministry decides when they can prosecute them, before they can be released? What nonsense is this? You tell me, guys. So, I mean, what jurisdiction in the world that somebody will go to jail forever without a time limit, and then they are released and they are remaining a dependent on another person deciding whether they're going to bring the case against them? You tell me. So the court is telling me, you and me today, that these jurors should remain in jail until the justice ministry can decide when to prosecute them. I would have said, of course, I'm not them. And maybe they even, what I'm saying, maybe they say that nonsense I'm talking to. I would have said, the jurors, because of contempt of court, they are ordered detained for 10 days, for 1 week, for 5 months, for 6 months. And within a time frame, the justice minister will institute a proceeding against them. Or they are detained for 10 days and the justice minister is authorized to prosecute them. But you can't say let them be in jail until the justice ministry can decide when to prosecute them. Guys, I got serious fundamental legal rights question about this. This is a violation of these jurors' right. They are entitled to a judicial process that is determinate. You can't put somebody in jail forever and say remain in jail until the other person can decide when they're going to arrest you and prosecute you. Why if the person did not decide to arrest and prosecute them in 1 year, they should be in jail? What kind of court can do that? So you look at the judge something, you look at the judge pass somewhere and you will say you were there that day, maybe you decide to do that. They investigate committee. So it says giving honor my hand and seal this 21st day of July AD 2026, Judge Usman F. Fega, assigned circuit judge presiding criminal assassin C for Mosorado County, Republic of Liberia. And that ends this reading. We're going to open the line right away. I don't know how much time I got there. Did I go to, is it 2 o'clock? Okay, so I'm going to tell my producer now, Eric is taking over. Eric will open the line and you signal me when somebody call. So the number to call are 0779077907. You place your call and tell me you heard the report. What is your perspective? 0779077907. And just signal me when they call and I will answer. Yeah. Okay, hello, caller. Oh, okay. Hello, caller. Okay, you go ahead and receive it.
Hello.
Yeah, go ahead.
Yeah, I agree with your analysis on 1, 2, 3. I have a different view to that. In how much it was established that the jurors were tampered with, and that is the case have to go to status quo. But the judge where he have to place the responsibility on another group of the persons to go and complete. So the point 1, 2, and 4 is worth taking.
So you are talking about where they said you have problem with where they said or they were unable to determine who were calling from outside and they want somebody to find them and prosecute them. That's what you're talking about.
Yeah. So what I'm saying, while it is true that what you say you make a point, but that cannot stop the case from going back to status quo.
Okay.
The only thing the judge can do, the only thing he should have done is to make sure to get those people. But in as much as have been established that the case that was being tampered, the juror was being tampered with, automatically the case have to go back. But the judge never completed his duty because he should have gone to the depth of the case to know all of those people who are start following with the jurors, so they will place them under the same custody. The last one is that you cannot commit somebody without time. So I think you make a great point to that. That should have been a time limit where within that time frame the justice ministry will start their investigation from there. So you make a point.
Thank you
Yeah,
very
the
much.
only thing.
Okay, let's talk
Okay.
to the next person. Let's talk to the next person quickly. Good morning.
Yes, good afternoon from my
Yeah,
end
yeah,
in
good
Liberia.
afternoon, my brother. Yeah, go ahead, you're live.
Oh, I'm Ezekiel A. Logan, calling from the Duboro end.
Go ahead.
Do you believe in your analysis? Do you believe that the juror was tempered with?
In my belief, the juror they have misconduct. If the
Okay, thank you.
juror temper with
Thank you.
another juror, I don't know how important that is, but I think they have misconduct.
But there's Samuel K. case. Do you believe that Samuel Twe agreed that yes, he took the money? Do you believe? Do you believe as a human? Do you believe?
I'm not in Samuel case situation, so I can't make that determination.
Okay, that's just my point. I want to stress that.
Okay,
thank you very much.
let's talk to the next person. Go afternoon.
Hello, good
Yes.
afternoon.
Yeah, go afternoon, you're live. Go ahead.
Mohammed, honest speaking to you from the Bush Island. I really appreciate your guests online on the platform.
Thank you.
I just want to add elementary happy Independent Days to you. Well, some of even though we're not satisfied with the celebration Independent Day, but not there. But I want to know. I don't know. And listen to him. Because one of the jurors was is a female, okay, and whereas she confessed, I think for me, I'm going to say this. She confessed and she said that they were tempered with, they were bluff, okay. So what is your answer to that? Yeah.
Oh, I already said what I wanted to say. I said, I mean, you can't be the violator and enjoy the fruit of the violation. So you are the one. You carry kung fu there. Nobody saw you, and then the case was decided. You voted against the person. You violated the judge order. You violated the court rules. You carry phone in there. You didn't tell the judge. You didn't tell anybody to hold you responsible or accountable. Now you went and voted against the defendant, and the defendant still was acquitted. You come back. You went home 9 days. Then you call the prosecution and say, you know what? I don't want to cause the trouble. Say I carry phone inside, so you can't prosecute us. You can't investigate us. I think
Okay.
that's nonsense.
Okay. You see, because the whole thing looking conflict because these children they are self-ruled, they have to take themselves to be blamed. Thank you.
Thank you very much for your perspective.
Okay, let's talk to the next person here. Go afternoon.
Good afternoon, brother.
Yeah, what is your name? Where did you join us from?
Yeah, my name is Anthony Gilman, calling from the rehab.
Okay, Anthony, go ahead, you're live.
Yeah, I listened to this. I don't know if it's a counselor or was he?
I'm not a lawyer. My name is Gibson.
Okay, I listened to the analysis. I think there's sense into the analysis. It's just a small little missteps, and the missteps are when you are guilty of one, you are guilty of all. So juror tampering and misconduct, they are all crimes that fall under the law and jurisprudence of Liberia. So they can determine how long you will stay in jail because you are not being charged and found that you are guilty completely. So for now, they'll keep you as suspect until they go through the case. So they decide when for you to be free. Because in this sense, you are free and you're walking around according to you. So they were walking all around, moving. Okay, then you came back to the court and say, "Oh no, we're doing it here. That's why I did. That's why I did." So all of you that was involved, to have to arrest all of you and verify what the person is saying, it makes sense. If it is true that it makes sense, the obviously all of you are still guilty into that. So the government now will maybe they are dead as salvage. Their own justice ministry will come up with the case and go through the case. If they are found guilty, okay, then they go back on, they will be released, then they be released. So I think they are moving in the right direction. Just that maybe there are two small little missteps from the right. Also, we can stay correct that brother. So everybody stay in the learning curve. Thank you for your analysis. I appreciate that. I mean, I learned something from you today.
Okay.
Thank you very much.
Okay, let's talk to the next person. Good afternoon.
Yeah, good afternoon.
What is your name? What did you join us from?
This is Ebi calling from Swing Market District.
Go ahead, you're live.
Yes, sir. I have one or two concerns. One have to do with the normal impressions that call everybody in that room. That is 5000698, and the other two is 689. Why can't the judge or the Liberian government subpoena the Doom Star to find out who owns this number? It's very easy. Because if the number can call everybody in that room, I mean, the judge have to determine who called those people. Number two,
And that's my question, my brother. And that's you and I asking the same question. The government of Liberia is interested in going and asking the judge to declare the case mistrial, right? But the
Yes,
judge,
sir.
but the government is not interested in going to find out or filing a subpoena for the person who owned this number, or to ask this telephone company to tell us who the number belongs to, because everybody register. The government is not interested in that. The court is not interested in that. And this person remain anonymous. We cannot know. And then the committee is saying, the judge is saying, no, somebody else must go do investigation to find out who the person is, and then when they find the person, they must prosecute the person. Why are you wasting our time?
It's a waste of time. Another question here is,
Yeah.
the same people who raising the allegations that they were tampered with, why they have to carry that cell phone inside there after they say, oh, the mail was not guilty or the mail was guilty, then they come out to raise case against themselves. Then they themselves to be held responsible.
Of course, yeah, I agree with you. And here's my problem, my brother. I don't want to influence the discussion today. But if I were on the other side to argue, if I were on Samuel Tua's side or the government side, one of the argument that can be put up is, look, how do I know that the government did not plant 2 people or 3 people in there and say, y'all go there, y'all must vote against the man, but y'all vote against the man, no way. The phone you're carrying over there, y'all must come and tell all them we'll go back on the case. It's possible. People can plan people. So that's why people are saying, hey, how come you the one who carry phone, you violated the judge rule, the judge tell you to go home, the case is finished, y'all stay home 9 days, then y'all come by and go tell the people, say, oh, we the one cause the trouble, y'all can investigate us. Who does that kind of thing before? Who wants to go to trouble like that?
Okay, I think you left the line
Okay,
already.
yeah.
Yeah, go ahead.
Okay, no. So, okay. I think
Okay, we
somebody
have
called.
another person here.
Yes.
Good afternoon.
Good afternoon.
What is your name? What did you join us from?
Yes, Ari Sabo Fela Tony from Central Monofia.
Go ahead, make your point.
I want to tell you guys thank you, but I think I want to disagree on a few things I said.
Yes, sir.
Yeah, one of the things is talk about the case, not talk about the trial for it, people who pursue. For me, if I were in Samuel Tua's shoe, I would be very happy for the case to be retried because it battled around integrity. I don't think Samuel Tua will be happy to be vindicated for a case where there will be a lot of controversy or where somebody say, oh, there was jury temper. So the fact that it's being established that there's jury temper, I think it's a good thing for him to go for a retrial. And the other thing I want to talk about is when they talk about the jury, I think the crime of competence is a criminal offense. I don't know how law is debatable, right?
Yes, you was on bill. Yes.
Yeah. So I think if they have good lawyer and they have lawyer, I think they can file bill and they can be other and go to court. I don't think the court will determine when they should count out. Once they have bill, I think it's a right to count out, right?
Well, yes.
Yeah,
If you file a bill, his bond have been returned. When you file your bond and you are not guilty, the court return your bond and tell you are a free man. You walk. It's
Yeah, I'm talking about
what you are saying. Our lawyers who I talked to say it is not practicable because if the government go against anybody and the jury say you are not guilty, the judge cannot overturn that verdict. That's what they're arguing. Government lawyers are saying it can be overturned because there was a misconduct or tampering. So the judge can overturn the acquittal. So that's
No,
what
I'm not
argument.
talking. Hello, I'm not talking about Samuel 12 bill. I'm talking about the jurors that are in prison right now. And their crime is criminal. I think they can be billed. Right?
Contempt. Yeah, contempt is criminal in nature.
Yeah,
Yes,
yeah, yeah, yeah,
yes.
yeah, yeah. That's what I'm talking about.
Yeah,
I'm
yeah,
talking
yeah,
about
yeah,
12. I'm
yeah,
talking
yeah,
about.
yeah.
So if they get good lawyer, the lawyer can file their bond and they can be billed. So I don't think the court
No,
can determine what they should.
contempt. You don't file bond for contempt. The contempt is a case against between you and the judge. The judge is the complainant. The judge is the judge, and the judge is his own witness. So you can't file bond for contempt. My problem with that is if my brother, what's your name again?
Tally.
Tally. So Tally,
Yeah.
if the judge say go to jail, Tally, but stay there until Gibson can decide to come and prosecute you. Is that fair to you? They didn't tell
No,
you how long.
yeah, if that's the case, because I think if that's the case, I don't think it's fair to them because there must be a timeline. The ministry of
Exactly.
justice will have to fast track. You know, our code are not meant to fast track the kind of cases. Sometimes it can take 2-3 years. So
Thank you.
the
Thank
person
you.
can be in jail for those time. All right, thank you for the show.
Absolutely. Thank you very much.
Okay. Okay, so I think you are out of time now.
I'm out of time.
Yeah.
What time is it?
It's already 2 o'clock. We got 1 minute past 2.
Oh man. Okay, give me 5 minutes. Let me conclude.
Okay, so we have another person on the line.
Okay,
Can I
that's
put
the
it on?
last caller, guys. Well,
Okay.
I'm out of time, so the guy want to kick me out of here. So,
Yeah, go after them.
what kind of men that treat their CEO like this?
Good
man?
afternoon, CEO.
Yeah, go ahead.
CEO Jerome Gibson. How are you, sir?
Yes, sir. Thank you.
Yeah, it's a pleasure, man. Our own CEO from our own Bliss Heaven. So have a discussion with you. Thank you very, very much for the radio station that beat everybody's imagination in this city.
Oh, thank you.
Yeah,
I appreciate it.
strictly to the point. Thank you. I heard it out. I heard the schedule today, but I went somewhere and I checked and got straight into the discussion. But however, let me take this time to extend my sincere appreciation to you for the very good analysis and the interpretation. I do respectfully agree with you in some article, but even only what I want to say is that what I want to say is that I don't know what the case stands for now, but I think George Usman Feka, he in wisdom, have the right and through the justice ministry to re-index Samuel 12 if and only as he said the evidence that he was looking for, they are getting the evidence to re-indict the juror so the case can be re-established. What baffles me is that Samuel 12 keeps saying to the public that as far as he is concerned, he is a free man. And what I want to understand, CEO, is there any other judicial prosecution can still go on with Samuel 12 again while the first verdict came up and then it said the verdict was tempered away by a few of the jurors? Can the case be reawakened?
Well, I mean, to be honest with you, I gotta be fair here. I'm not a lawyer, so my opinion will be based on my little legal knowledge from my paralegal studies for 3.5 years, almost 4 years. But here is what I think is happening here, and I just want the whole public to understand. Number one, to go back to trial means will be expending government resources on a case.
Exactly.
Yes.
CEO.
Yes.
That's where my question is coming from.
Correct.
Because the case have been dealt from the initial stage. People, the juror never clean this process.
All right. Thank you very much. We are out of time, but I just wanted to borrow a little bit of 5 minutes here before the guys kick me out. That tells you that I don't override things here. The guys control me, control their time. And I want to say thank you. We're not taking call anymore. We are going to be discussing, let me just say, tomorrow, no, not tomorrow. Yeah, tomorrow, the OB crew is going to be in Buchanan. Eric, just give me a few time, please. If can I pay for 30 minutes? You see, when it comes to money, then you're laughing. Eh? Okay. So, the OB crew and myself, we are going to Buchanan to cover the July 26th celebration. The president is in Buchanan, and we are going to bring you live commentary from our radio station. For those of you who are listening to us through our online radio station around the world, you have to relax. We are going to bring live commentary from Buchanan. It's going to be live on the local radio station in Monrovia. It's going to be live on our international radio station. It's going to be live on our Facebook page. It's going to be live on our YouTube page. So we are doing that tomorrow. I myself am going there with a crew. We are going with 3 different teams. Myself, I might be on the computer. Myself will be there to transmit. So thank you very much, and we want you to follow us. Also, there are other cases that I made research and I have here to indicate, but I'm not going to talk about them. We're going to talk about them tomorrow when Akaros Gray is going to be here to talk about this case here tomorrow. I have cases here that and other legal instruments that says you cannot bring a case back when the acquittal is made. So I will quote these cases tomorrow and then we'll discuss them. So Akaros Gray is going to be here tomorrow by 4 o'clock, and the program starts 4:15 right after the news, and we'll be here for 45 minutes, Akaros Gray and myself. On Wednesday, we will be bringing in the man Mo Ali. Mo Ali is coming on Wednesday. And Wednesday conversation will be mainly to talk about the water and sewer. So for those of you who know about water and sewer, who got concerns, that will be the best time for you to talk to the managing director of the Liberia Water and Sewer Corporation, and that will be Wednesday. If you have any question, you want to send them to me. If something is happening to the water and sewer that you think the management team need to know about, it is our responsibility as journalists to bring the thing out to the management team. And Mo Ali is going to be here to take your questions, to take your comments. And if you know anything, please send it to my number 0881 301000. Send me text message. Don't call me, guys. I will not answer most of your call. Just send me text message 0881 301000. 0881 301000. This number I'm giving you, don't call me, please. Just send me text message. I don't want people flooding my phone with calls. Okay, please. I just trying to do my job here. Send me message about any water situation that you know is existing, so that Mo Ali can look into that tomorrow. On Thursday, Samuel Jackson, the first time in studio interview, he will be right here. Samuel Jackson. Also on Thursday, we have invited Wilmer Pay. So we're not too sure of Wilmer Pay, but we are sure of Samuel Jackson. Samuel Jackson will be here on Thursday. On Friday, it's a battle that we're going to be fighting here. I'm bringing Abraham Gosson William. He and I will fight in the studio. We will argue in the studio. And tomorrow I'm going to be taking Friday, I'm going to be taking the government side. And Abraham is going to be taking the opposition side. We will argue the point, and you tell us who will win. And for now, I want to say thank you very much for listening to me. My name is Gibson, and it is all good. Thank you very much, Eric, and I turn it over to Eric to continue the broadcast. Thank you, and bye-bye.